Good afternoon and welcome to the Environmental Law Institute. You have joined us for the Summer School Series seminar, Basics of the Clean Air Act. My name is Chandler Randall and I am so delighted to welcome everyone to today's webinar. I encourage you to join us here at ELI every Tuesday for summer school. For more information, please join the events page of our website, eli.org. And at the end of today's panel, we will have time for a Q&A session. Please submit your questions through GoTo's question box and please do not wait until the end. Send us your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their expertise to summer school. While I will introduce them briefly, the full speaker bios are posted on our website, www.eli.org, and I would strongly encourage you to check out their expertise in more detail there. As we begin, I would like to briefly introduce our panelists. Sarah Colangelo is the Director of the Environmental Law and Justice Clinic and Visiting Professor of Law at Georgetown University Law Center. Professor Colangelo's areas of specialty are environmental litigation and enforcement, including community considerations and the enforcement process. Previously, Professor Colangelo served as a trial attorney for the Environmental Enforcement Section of the Environment and Natural Resources Division at the Department of Justice. We also have with us Rachel Levitt-Corley, an associate in the Washington, D.C. office of Gibson, Dunn & Crutcher. She practices in the firm's litigation department and is a member of the Environmental Litigation and Mass Torts Practice Group. Ms. Corley has represented clients in a wide range of federal and state litigation, agency enforcement actions, cost recovery cases, and administrative rulemaking challenges. And last but not least, we have Gary Steinbauer. Gary is a shareholder in the environmental group of Babst Calland. Mr. Steinbauer advises clients in a wide variety of matters arising under major federal and state environmental regulatory programs. He devotes a significant portion of his practice to advising clients on issues arising under the Clean Air Act, Clean Water Act, and related state programs regulating air emissions and water discharges. He handles air and water permitting matters and appeals and helps clients facing federal and state enforcement actions. Sarah, Rachel, and Gary, we are so glad to have you with us today. And with that, I will turn things over to Sarah to get us started. Thank you all so much.
Great, thank you, Chandler. And thank you so much to the Environmental Law Institute for having me back again to teach in the summer school program. This is always an excellent series of events. So thank you so much for joining today. This particular series has the very noble aim of introducing elements, issues, and statutes in environmental law to pre-law students, current law students, and early career practitioners. So my goal today, let's navigate to my particular slides. Okay, so my goal today is to provide a foundational overview of the Clean Air Act, discussing why we need federal legislation in this arena, reviewing the context in which the statute was enacted in its current form, including the goals of this particular statute, and then exploring some of the themes, issues, and regulatory design choices, indeed tensions really, that we find echoed throughout federal environmental law. And I'll use a portion of the statute as an example when I walk through that. So the Clean Air Act is arguably the most complex federal environmental law on the books. And for that reason, whenever I introduce the act to students or professionals, it's critical to focus on what the problem is we're trying to solve. And it's that type of building block and foundation that's going to allow us to build and layer on some regulatory nuance once we really have that foundational understanding. So for that reason, I start with why this type of pollution occurs and why we need federal regulation in the first place. Then I'll move to the mix of policy and regulatory instruments we see in the Clean Air Act that are used to achieve our environmental objectives. Here, clean air or cleaner air. So high level, what are some of the strongest rationales for why legal protection of the environment is necessary? Many of them are rooted actually in economic concepts. So I'm going to touch upon this very, very high level, very briefly. So for example, the concept of externalities. and that is a side effect or consequence of an industrial or commercial activity that affects other parties without being reflected in the cost of the goods or services involved. So a common example, oh, I must have hit something, excuse me. Let me go back. There we go. So a common example of a positive externality is the pollination of surrounding crops by bees kept for honey. Air pollution is obviously a negative externality. So when we think of air pollution from fossil fuel power plants or chemical manufacturing plants or refineries, those are negative externalities. There's also the concept that may be familiar to many of you called tragedy of the commons. Here, putting something in, pollution, to common media, the air. And the rational actor finds that the cost of disposing of their share of wastes into the commons is less than the cost of purifying before releasing. So those are a few of the reasons why we end up with air pollution, very simply distilled. But the next step is to ask ourselves, why this form of legislation? Why couldn't market forces alone solve this problem for the temptation to pollute? And there's a lot of different answers to these questions, but I'm just going to give you a few general ones right now. So first, as I mentioned, we have these pollution externalities, or this type of externality that can cross borders. Air and water, they move. And so states can sometimes find themselves with little incentive to abate their own interstate pollution or pollution that's caused by their industries unless a higher form of government imposes such a requirement. Second, common media like the air can't be privatized. So you can't be given responsibility just for your own little airshed, for example. And third, efficient markets and rational behavior really often depend on participants having perfect information about market choices. That's just not the case when it comes to air pollution. And there's also a serious power asymmetry, oftentimes, and information asymmetry as well, with polluters or sources of pollution and certain types of communities. So with air pollution, we're missing pieces of key information. Producers sometimes don't know who or what will be harmed, where their pollution goes. Victims don't know when they've necessarily been in contact with pollution or the frequency with which they were in contact with that pollution. And there can be periods of great latency between exposure and the effects of that pollution. There's also issues of transaction costs that prevent people from getting together, often to come to consensual solutions or demand action from localities or states, for example. And again, I just highlight there's some equity issues here in terms of sources of pollution co-locating in areas where people may be marginalized or disenfranchised. And there's other concepts, again, this may be familiar to the audience depending on what you've read or studied perhaps earlier, but we have the free rider problem and a concept called race to the bottom. The free rider problem posits that that people may hope others will take the laboring oar to solve a problem or take on the burden of finding a solution. So the idea here is that without a national approach or without consistent standards across states, people would stop taking action, assuming someone else might clean up their air. And of course, we have the concept of race to the bottom, which theorizes that states may engage in competitive deregulation to incentivize businesses to stay in their state. So that's a very, we just ran through a whole lot of concepts, but just to give you a very cursory review of some economic theoretical approaches to pollution, with the discovery that some combination of legislative, regulatory, and judicial intervention is going to be needed in order to secure clean air. Okay, so what we refer to as the Clean Air Act is really a collective set of amendments to the Clean Air Act of 1970 and beyond. The versions of the Clean Air Act prior to 1970 focused on things like research, some monitoring, but were really involved at most regional approaches to pollution control and essentially had no teeth. Before that, I always remind the law students in the crowd and really everyone, but especially those law students who are maybe just finished studying torts, that before these pieces of legislation, there were, of course, common law doctrines for pollution control, including nuisance and trespass and the like. Let's talk about the Modern Clean Air Act. And that really arose out of a confluence of social movements and awareness, scientific and epidemiological evidence and advancements, and political coalescence around the importance of public health and air quality. Now, some of this sprung from public health tragedies from air pollution, such as mass fatalities in London and New York, for example. And ultimately, remember, President Nixon was looking for a reduction of air pollution to be his moonshot. He looked at it like his moonshot. And he ultimately signed into law the Modern Clean Air Act, which of course did take the national approach I've been previewing in some of my earlier remarks, and did have teeth, including technology forcing approaches, deadlines for administrative agencies to take certain actions, and the like. So the goal of the Modern Clean Air Act is to protect and enhance the quality of the nation's air resources so as to promote the public health and welfare and the productive capacity of our population. And while this is a bit of a rote incantation for those of us who practice in the area when we conduct written or oral advocacy, I still always say it. It's the touchstone against which, or one of the touchstones against which the Act is interpreted, and it's still important as we build upon our understanding of the Act and we engage in grappling with some of the complexities of the Act. It's very helpful to be able to hearken back to the purpose of a statute, and again, the purpose of each regulatory program as we walk through them. And the Act provides us several tools to meet this goal. Very, very broadly speaking, I want to introduce a few of them to you. So we have rules and regulations governing pollution and polluting entities, which we call sources. And those rules are often translated into permits. And these things are enforceable by the federal government, by states, and by private citizens or citizen groups. But there are also voluntary incentives to reduce pollution. And the Act also incorporates and mandates many types of monitoring, modeling, and other mechanisms of information gathering and information sharing as well in public education. So you'll note as we explore some, but certainly not all of the titles and programs under the Act, you'll see that each reflects a set of regulatory design choices selected to address a particular problem while always aiming to meet this overarching goal that I have written on this slide. And the Clean Air Act is comprised of several titles that I've listed here, and some of which have been altered or added through the amendments of 1977 and the more comprehensive amendments of 1990. What's interesting when you speak to the people that were involved in crafting the 1990 amendments, they often say that they never assumed that the law would essentially remain ossified for the next 30 years. But we really have not had any evolutions in the law since that time. Okay, so now as I mentioned at the outset, and as you can tell from the last slide, the Act it goes without saying, incredibly complex and dense. We could certainly spend a year teaching the Act in law school. I don't know that law students would necessarily enjoy that all that much, but maybe there would be some that would, but we still, I don't think, would ever get through it all. And while my colleagues, my co-panelists will cover certain sections in greater detail, I thought it would be useful to highlight some themes and issues we see in the Act that are echoed throughout domestic environmental law. And I do this, I might not do this with another panel, but with this specific audience, I thought it would be helpful to give you some takeaways that you could apply broadly when you approach other laws, especially because many of you are in a learning posture. Well, we're all still in a learning posture. I know I am. I think everyone's still in a learning posture, especially when it comes to the Clean Air Act. But when you're in a development stage and in an education stage in your career, I think it's helpful to have these takeaways that can apply to other statutes as well. So with the Clean Air Act, it really is all in there. Everything that we could cover in terms of regulatory design issues that we encounter, we really encounter them in the Clean Air Act. So the myriad of regulatory design choices we face when tackling air pollution involve questions of technology-based or with what are called technology forcing regulations and provisions, federalism and regionalism conflicts, centralized versus decentralized decision-making, including enforcement, and questions like, should we use what's called command and control techniques? Should we look towards innovative and incentive-based techniques to get the air pollution control that we're looking for? Should we focus on new sources or existing sources of pollution? What about mobile sources versus stationary sources? So it's very complex, the choices that we have to make. And then there are those themes that I mentioned that we see across environmental law raised in the implementation and the provisions of the Clean Air Act. Always facing tremendous difficulty when we're dealing with statutes that are seeking to regulate environmental issues, in particular to deal with human health-based harms, especially including issues of scientific uncertainty. There are nuances here of transboundary questions. There's complexity of current events, and of course politics play a big role in that. But current events in particular with relation to the Clean Air Act, we're seeing a major focus on climate, a major focus on the transition to clean energy sources, and a major focus on environmental justice and equity concerns. All right, so for the remainder of my time, I'd like to briefly use one of the programs to illustrate some of the issues and themes that we've been discussing. And that's the National Ambient Air Quality Standards, which we refer to as the NAAQS, because the practice of environmental law is flooded with acronyms, and I apologize, that's just how our practice is. It's your job as an advocate when you're speaking to a court who are generalists, you have to simplify it for them. But when you speak one-on-one to other practitioners, you've got to use the jargon, and I apologize for that. But we're going to talk about the NAAQS and the SIPs, which are the state implementation plans. And these are found in Title I of the Act. And the NAAQS and the SIPs I've chosen because they're really exemplars of the cooperative federalism approach in environmental law. And by that, I mean a partnership of duties and responsibilities. The federal government is charged with identifying air pollutants and setting standards and revising those standards, whereas the states and localities are charged with developing plans to meet the standards, which consists of monitoring the air, issuing construction and operating permits, for example, and doing the majority of inspections as well. So the NAAQS are really our attempt to regulate certain pollutants found everywhere, or mostly everywhere, in the United States. And under the Act, EPA must list what are called criteria pollutants. And these are widespread pollutants reasonably expected to endanger public health or welfare. And their presence is due to numerous and diverse sources. So we have ground level ozone, particulate matter, carbon monoxide, lead, sulfur dioxide, and nitrogen dioxide. And EPA must establish the national standard, which is a numerical air quality standard, for each pollutant sufficient to promote public health and allowing an adequate margin of safety. And I highlight this program because these regulatory choices and the statutory language here reflects some of the current themes that we were speaking about, or I should say, excuse me, recurring themes that we were speaking about that we encounter with a health-based regulation. So in other words, I've paused on that language with an adequate margin of safety. So when you're dealing with these types of regulations, how safe is safe? Is there a safe level of pollution? How do you control for risks? How do you deal with scientific uncertainty? We saw this, for example, play out regarding the standard for lead as the epidemiological and scientific evidence regarding blood lead levels and associated health impacts evolved. And more recently, again, we're confronting a new set of issues, finally confronting a set of issues that when we set national standards, are we considering at all and are we protecting communities with legacy pollution from multiple media, air, water, hazardous waste exposures, and who, as a result, are more vulnerable populations? So once EPA has set national standards, our benchmarks for ambient concentrations of these pollutants, the question becomes, how do we get there? Who decides how we get there if the current air quality isn't good enough? Alternatively, what if we're there? What if the air quality is good? How do we maintain that air quality? How do we keep it that way? And these are the concerns that really drove the creation of the state implementation plans and programs like the prevention of significant deterioration. I pose these as questions because, again, when we're diving into the nuance, and the PSD program is incredibly complex, when we start to dive into those areas, I just encourage you to take a step back and say, what is this provision trying to address? And it's really getting at those questions. So now, drilling down a bit, just as a reminder, the establishment of the NACs do not by themselves directly regulate emissions, but rather set legal limits on concentrations in ambient air. So it's now up to the states in the first instance to achieve those limits through a series of steps. Designation of areas within the state as either in non-attainment, attainment, or unclassifiable for each criteria pollutant, and then creation of the plan to achieve or maintain the NACs. Okay, so that we have that, each of those, as I mentioned, from section 107 and section 110 of the Act. Okay, so let's talk about SIPs and the SIP process now. The SIP is a federally enforceable collection of emissions limitations, simply called a plan, that specifies how a state will maintain or attain compliance with the NACs. And I do want to highlight a few details here. So under section 110, a SIP has to include enforceable emissions limitations and schedules for compliance to achieve the NACs, incorporation of what are called technology-based emission limitations, air quality monitoring plans, enforcement program, and requirements. There's also a requirement to consider pollution impacts to downwind states. And there we go, my apologies. My cursor was a little bit slower than my mouth, which happens sometimes. All right. And another nuance that I do want to point out, how do we try to get our air cleaner when certain areas are in non-attainment? Well, that results in more stringent requirements when that's the case for those specific airsheds. So for areas designated in non-attainment, a state has to demonstrate that it will make reasonable further progress towards achieving attainment, require a pre-construction permit for any new or modified major source, and require emissions offset. And now, so this is what I've titled this slide, Accountability in the SIP Process. But it's really something you could think of as this is that cooperative federalism dance in play, okay? This is the shifting balance of power between EPA and the states. So states get to choose the methods for achieving the state's air quality protection and improvement goals. And when they do exercise that discretion to choose the best plan for that particular state, they can consider certain economic and technical factors for their polluting industries and sources. But there is accountability and federal oversight baked into that process. So ultimately, if EPA doesn't find a SIP adequate, under Section 110, it can impose a federal implementation plan. Of course, we all have to shorten that to what's called a FIP, increase the amount of offsets required for any new or modified source, or withhold federal transportation funding, okay? And just a note here, this is a fluid process. Well, it's actually a very slow process. So fluid is maybe an aspirational term. I can at least say it's not a static process. So by that, I mean states do revise their SIPs and they do redesignate regions as air quality improves. So Section 110 requires that SIP revisions be preceded by reasonable notice and public hearings at the state level, and prohibits EPA's approval of a revision if it would interfere with any applicable requirement concerning the attainment of the NAAQS, reasonable further progress towards attaining the NAAQS, or any other applicable requirement of the Clean Air Act. So the takeaway from this slide and a couple of these details are really that this cooperative federalism dance has its rules, and the discretion and actions of both states and EPA are bounded by the Act and regulations. And now I just want to finish with two very broad sets of points. The first, again, is to say just how complex this area is and how granular a practice it can be if you're considering going into this particular practice area. I love working on these panels because I know I'm going to get to hear about what Gary does and get to hear about what Rachel does, and that's always so interesting to me. In my past life at DOJ, just to give you a little example of how granular the Clean Air Act can be, I've had cases focusing on a set of regulations governing the incineration of hospital medical infectious waste called HMWs. I've also had a big case arising under 112R, which is the chemical accident prevention regulations, to protect workers and frontline communities against a Bhopal-like disaster. And I raise that again just to say, if you practice in the Clean Air Act, it's not necessarily all power plants and mobile sources. There's a wide variety of work that you might end up doing under the Clean Air Act. Which is again what makes it so challenging and fun, because you never could master it all. And the second thing I want to highlight before turning it over to my co-panelists is just the period of change that we're in environmental law right now. And I think we're really going to see some changes come about when we're talking about Clean Air Act implementation. We've got regulatory interpretation that may change at the federal level. Certainly, we have an entire crop of new leaders at the heads of our regulatory agencies. And one of the things that I think is important to note is how much we're seeing the federal government, state governments, localities, citizen groups, and industries as well, whether voluntarily or at the advice of counsel, all really taking into account seriously, I hope, the impacts of air pollution, the disparate impacts of air pollution on communities of color and low income, and communities suffering from legacy pollution from multiple sources, as I mentioned. I also think this period of change is going to be positively affected by flourishing lower cost technology and pieces of technology that will impact things like air monitoring, for example. And of course, it goes without saying that we're going to see a tremendous, I think, change when we think about a carbon-based economy and energy sources and climate change. So there's a lot we could talk about in the question and answer session in terms of likely areas of focus in the Clean Air Act in the future. And then I also always offer, I know there's a lot of law students or future law students in the audience, so I am happy to chat and answer any questions that you may have about a practice in this area. Thank you so much.
Well, thank you so much, Sarah. I really appreciate your thoughts here, and I thought that was a great overview for us to get started. I will now hand things over to Rachel. So over to you. Thank you so much.
Great, thank you, Chandler, and thank you, Sarah, for just a really fantastic overview. You set me up extremely well, because what I'm going to do is a little bit of a deeper dive into one specific area of the Clean Air Act. But before I get started, I just want to say thank you to ELI for hosting us and for giving us this opportunity to speak today, and also to Sarah and Gary for sharing their expertise with the group. So today I'm going to walk through three key Clean Air Act programs that focus on stationary sources. This is one element of the framework that Sarah provided an overview for. And as I said, she really set me up nicely to talk about things like cooperative federalism and the partnership between the federal government and the states in regulating clean air. And so within this presentation, we're going to talk about these three programs listed on the slide. And in particular today, I'd like to talk about how those programs are implemented in practice, as well as focusing on some practical tips for attorneys, for companies, for industry, for regulators, to determine the applicability of each of these Clean Air Act programs to the stationary sources that they regulate, as well as helping provide some guidance for determining the relevant requirements that might apply to each such program and to each such source. So as you can see on the slide, the three programs that I'll focus on today are the New Source Performance Standards, which, as Sarah previewed, yet another acronym, you will hear lots of them today, we call NSPS, the National Emission Standards for Hazardous Air Pollutions called NESHAPs, and then the New Source Review Program. And so these are the three key programs from a compliance perspective and an enforcement perspective for stationary sources as well as for states. And so I'd like to start with the New Source Performance Standards, or NSPS, as I noted. This program addresses criteria pollutants and their precursors, such as volatile organic compounds, or VOCs. Now, the NSPS are aimed at preventing the deterioration of air quality from the construction of new sources of air pollution, but also as well as from major modifications to existing sources of air pollution. So kind of a old versus new framework here. Now, NSPS regulations are generally organized by industry. And so you'll see on the right-hand side of the slide here an example showing how EPA develops NSPS regulations across a wide array of industrial fronts. So paper mills, glass manufacturers, boilers, refineries. Now, this is just to name a few. This is by no means an exhaustive list. And you can see at the bottom of the slide where I've set forth the regulatory and statutory requirements in the Clean Air Act that list each of the relevant industrial groupings. And you can visit those if you're curious to see just how extensive EPA's regulations are in this front. And so each industry is set out in an individualized, alphabetized subpart within 40 CFR Part 60. And so you'll see things like, subpart CC, glass manufacturing plants, and it's nicely compartmentalized within that section of the Clean Air Act. Now, there are also NSPS standards that are organized by operations as opposed to industry, and operations that are common across many industries. And so this could be something like regulations for equipment leaks or regulations applicable to storage vessels. And those regulations for so-called typed operations may appear across multiple types of industrial sites. And so in recognition of this reality, EPA promulgates NSPS for those common operations and then generally incorporates them by reference into the specific source NSPSs. So as I noted, there are approximately 100 source NSPS regulations in effect, and they can be found at 40 CFR Part 60. As noted, they're organized generally by industry or operation, with each subpart having its own alphabetic designation, so you can easily locate the regulations applicable to your particular source. Now, for each particular NSPS, so for each self-contained source or type of operation that's governed by this program, the regulation is generally, as I said, fairly self-contained and follows this who, what, how framework listed on the slide. And so first, you'll want to look at the regulation to determine the applicability. And for the NSPS, this will be based on the date of construction or the date of the modification of the source at issue, as well as the potential emissions from the regulated source. And so you'll hear the phrase potential to emit, or PTE, several times throughout this presentation, and we'll get into that in a few moments. But for present purposes, I just want to flag it's a two-pronged test for NSPS applicability. First, the date of construction or modification, and then second, potential to emit. Next, the NSPS defines source and operations within a facility to be addressed by the regulation. So for example, on the earlier slide, we saw that there's an NSPS for paper mills. Now, the regulations do not prescribe a numerical limit for the entire paper mill. Rather, it looks within that facility and designates certain equipment or operations that will be subject to the NSPS. And so taking the paper mill as an example, NSPS would have numerical limits or standards for the boilers within that paper mill or the paper machines that are within that facility. And those are known as the affected facilities within the NSPS. Third, for each affected facility, the NSPS will have substantive requirements that dictate how one determines compliance for each affected facility. So for example, that will often take the form of a numerical limitation, like a concentration limit expressed as parts per million or parts per billion, or it could be a question of the efficiency of a control device that says if you have this type of emissions, you must route it through a control device, and that device has to reach a certain percentage of efficiency, say 95 or 98% efficiency destruction for your emission. Now, one other point to note on this slide, if you're starting to look at NSPS regulations to determine if it applies to a particular source or operation or facility, you'll also want to couple your review of the industry-specific NSPS with a review of subpart A. And that's the general section at the beginning of the NSPS that provides a lot of basic requirements applicable across the subsections. And so these two should be read together. So for example, subpart A often supplies reporting or testing obligations, and particularly where those are not further specified within the individual NSPS section. And so it's imperative to review not only the specific NSPS section applicable to your operation or industry or facility, but also to check for any generally applicable provisions of subpart A. Now, in terms of determining compliance with NSPS, or determining, in other words, if you have a regulated source and whether it's compliant, you first want to check whether your industry or type of operation is in fact covered. And you can do this, as I showed a few slides back, by visiting EPA's website and looking at the table that they have listing the NSPS for each industry or type of operation. And you can easily just click on each entry to obtain a copy of the regulation uniquely applicable to that source. Now, another way to tell applicability is to obtain the industrial code that covers the facility and comparing that to the applicability tables at the beginning of the NSPS regulation. If you find a match, the rule will then tell you what the affected facilities are within your particular operation or facility. And again, that's the specific equipment or operation that will be covered. Next, you should ask whether your affected facility was constructed or modified by the relevant applicability date. And again, that date will be set forth in the specific NSPS at issue. And then finally, if the answer was yes to all of these many questions, you'll need to determine whether the affected facility's potential to emit, there's that PTE term again, is over the threshold that's set forth in the rule. And so we've put a little example on the right-hand side of the slide. Let's say that you are advising a fracking company that's involved in upstream oil or natural gas production. Now, that type of operation is governed by NSPS subpart Quad O or Quad OA, as we said, neatly organized by alphabet. And looking at the Quad O regulations, the affected facilities at the fracking site include a number of things like compressors and storage vessels. And so for purposes of this specific example, I'm going to go with the storage vessel example. So the applicability date for Quad OA, which is the more recent NSPS regulation here, is September 18th of 2015. And so you would take a look at your storage vessel, determine whether it's been constructed or modified after that date. And if the answer is yes, then you need to determine whether it had the potential to emit over the threshold in the rule, which in this case is 6 tons per year of VOCs. If you get to the end of that inquiry and you've determined that the NSPS is applicable, then the rule will tell you that for storage vessels, you need to route the emissions back into a process or to a combustion device that destroys the emissions to a 95% efficiency rate. And at that point, the rule will also tell you that there are a number of work practice requirements and reporting requirements that will be applicable as well. So a few broader points about NSPS before I move on. Unlike some of the other programs that I'm going to cover today, the applicability of the NSPS is the same, regardless of the geographic location in which the facility is situated. So in contrast, for a new source review, the permitting program, the requirements vary based on whether the facility is in an attainment or a non-attainment area. And thanks again to Sarah for setting us up on what those terms mean. The NSPS does not work like that. Rather, it's uniform across the country. And so for that reason, one way to think about NSPS is that it creates a technical floor to ensure that similarly situated facilities are operating with comparable emissions and technology nationwide. So the next program I'm going to cover is the National Emission Standards for Hazardous Air Pollutants, or NESHAP. Quite a mouthful, which is why we have abbreviations. So unlike the other two programs in today's presentation that I'm going to cover, NESHAP covers hazardous air pollutants, also referred to as HAPs, as opposed to criteria pollutants and their precursors. So examples of HAPs include things like benzene or toluene or xylene. And EPA has a statutory obligation to set the NESHAP requirements for sources emitting HAPs. Now, similar to what we just saw for NSPS, NESHAPs are organized by industry or by type of operation. And so for those sources that are regulated by NESHAP, each source must apply what is called the Maximum Achievable Control Technology, or MAC, to address the hazardous air emissions. Now, MAC is such a key feature of this rule that you will sometimes hear the NESHAPs referred to as MAC rules. And that's particularly true if you're referring to a specific subsection applicable to a particular industry. So to really hit home the alphabet soup example of what this practice can sometimes look like, you'll sometimes hear the NESHAP for the miscellaneous organic chemical manufacturing industry, or MON, which is one of the specific NESHAP subparts, referred to as the MON MAC instead of the MON NESHAP. And people may use those terms interchangeably. So if you hear the MON MAC thrown around, just remember it's going back to the NESHAP. Now, similar to the NSPS example that I covered earlier, the NESHAPs are fairly self-contained rules. And so they can tell you what sources are regulated, what equipment and operations are going to be subject to the standards under the rule, and for those regulated equipment and operations, what the relevant standard is and how to demonstrate compliance. And so as you'll see on the slide here, NESHAP applicability is first defined by the source category and potential emission threshold. So for example, 10 tons per year of an individual HAP, or 25 tons per year of a combination of HAPs. Second, the specific NESHAP will define what equipment and operations are subject to those regulatory standards. Now, unlike the NSPS, the NESHAPs do tend to divide equipment into different groupings. And so rather than having one standard that applies once you've determined that the NESHAPs are applicable, sometimes the NESHAPs will have various subcategories of regulation within each regulation. But in general, the NESHAPs work the same as the NSPS in terms of organization by equipment and operation. And once applicability is determined, facilities must comply with the MAC standards for the specific sources of HAPs. And this usually takes the form of emission limits for specific pieces of equipment or work practice standards. Now, digging further into what is regulated, NESHAP standards focus in the first instance on major sources. So all NESHAP standards define major source applicability the same way. A major source for purposes of NESHAP is any stationary source or group of stationary sources that emits or has the potential to emit 10 tons per year of any single listed HAP, or 25 tons per year of a combination of HAPs. So for example, if I was working with a facility that had the potential to emit 11 tons of benzene, that's a potential major source for purposes of this program. Now, you could also have a major source if your facility had a PTE of 9 tons of benzene, 9 tons of toluene, and 9 tons of xylene, because you'd be adding them all together and then you'd be over the 25 ton per year HAP limit. Now, there is an important part of this rule not to overlook. In addition to the major source category, the regulation also focuses on other things, specifically those facilities that emit HAPs that don't qualify as a major source under potential to emit. And those are called area sources. And area sources have separate requirements that you should also evaluate when you're looking to ensure that you've complied with the requirement, perhaps. Now, as I've noted, you kept hearing me use this phrase, PTE, potential to emit, and this is pretty common across all the programs that I'm going to discuss today for stationary sources under the Clean Air Act. The PTE is the maximum capacity of the source to emit an air pollutant under its physical and operational design. So when you calculate PTE, you assume that the source is operating 24 hours a day, 365 days a year at maximum capacity and without control in place. That is, unless the facility is subject to a federally enforceable state permit limit, which can address or limit its operations. And those permit conditions can be considered in the PTE calculus, but they must first satisfy certain legal requirements before those conditions become federally enforceable and can be considered as part of calculating the PTE. So again, as with the NSPS slide, I wanted to provide a little bit of a practical example of what NESHAPs look like. So here I picked the NESHAP standard that governs the chemical manufacturing industry. It's called the SOCME Act or the SOCME NESHAP. And you can see here how the rule defines what is covered. First, look to see if your source meets any of the potential to emit thresholds, and if you have one of the relevant industrial codes that would fall under this regulation. If so, then under this particular NESHAP, one of the regulated sources are the process vents that are actually used in chemical manufacturing. And this is in addition to the facility's wastewater or storage tank or any equipment leaks. And so once you're within that rule, you then determine which of these types of equipments or operations you have, and the rule will tell you for each what the relevant standard is for control, as well as how to demonstrate compliance. And this includes any monitoring and reporting requirements. Now, as I alluded to earlier, NESHAP also addressed sources that emit HAPs below the PTE thresholds. And again, these are called area sources. So the area sources are organized in a similar manner to the NESHAP, but they're less onerous because the MAC standard doesn't have to apply in terms of the relevant control technology and limits. And so the key point here is just to remember to check for an area source requirement if you're evaluating a potential regulatory requirement for a source, even if it doesn't qualify as a major source. Okay, and last but not least, I will cover the New Source Review Program, or NSR. Now, this program requires owners and operators of new and modified sources to obtain permits with appropriate limits and control technology prior to undertaking construction or significant modifications. And the purpose of this program is to maintain compliance with the National Ambient Air Quality Standards, or NAAQS. Now, NSR is implemented through a state-specific permitting program. In other words, the NSR is generally outlined at the federal level, but then is incorporated, as Sarah alluded to, into the SIPs, or the state implementation plans. And so you have to remember to check both sources when you are trying to determine compliance with NSR. I think the slides are jumping around a little bit. Bear with me one moment. There we go. And so in this regard, I'll note that NSR is somewhat localized or customized to a particular region because it's implemented through a permit that applies to a specific facility. And so this is in contrast to the other programs that I've talked about where the federal rule will tell you what the emissions or numerical limit is and the control technology you need to use. Now, another key element of NSR is that it can vary based on the area in which you are operating or constructing or modifying a source. And this is important to note as it relates to the attainment and non-attainment areas that Sarah discussed at the top. So sources that are in attainment for the NAAQS can secure state permits for construction and modification under the Prevention of Significant Deterioration Program, or PSD. As Sarah said, PSD is highly complicated, so we'll try and keep it at a relatively high level here. But it's important to remember that if you're in attainment, the PSD program is available. In contrast, if a source is operating or will operate in a non-attainment area for the NAAQS, then it will need to secure non-attainment NSR permits, or NNSR permits, for the relevant state and local permitting authorities. Now, the applicability of the NSR program, and specifically whether the facility needs a permit for construction or modification, again turns on potential to emit, much like the other programs that I reviewed today. Now, the thresholds vary, so it's somewhat more complex to determine whether you need a pre-construction permit under NSR. And so we've listed a little bit of information on this slide on this topic as well. Now, for new construction, the Clean Air Act lists 28 sources, broad categories that are laid out at 42 USC 7479. And for those 28 source categories that are identified, the PTE standard is 100 tons per year of any regulated NSR pollutant. Now, if your source is not listed as one of these 28 sources, then the trigger is 250 tons per year PTE for the NSR pollutant. Now, for modifications, in contrast to new construction, the PTE threshold is actually a little bit more tricky. And so you'll see on the right the variety of the thresholds that could apply, but generally the thresholds for modification will depend on the specific pollutant, as well as the area in which the facility is located and its attainment status. So as I mentioned earlier, the requirements for the NSR prevention of significant deterioration, or PSD, is outlined at a high level in federal regulations. Now, there are going to be more specific details in the state implementation plan, and so it's very important to consult the state regulations for this and all the programs that we discussed today. In general, for sources in attainment areas that are undergoing PSD, they must secure a pre-construction permit for the proposed project that utilizes the best available control technology or BACT for its emission units. The rule also requires PSD sources to conduct air quality analyses to ensure that it won't increase emissions in a way that will impact air quality. And this permitting process is actually subject to public involvement via the public comment and hearing process. Now, in contrast, for sources that are in a non-attainment area, they also need to secure a pre-construction permit from the state or local government, but sources in non-attainment areas will undergo a more rigorous process. And so the state permitting agency will evaluate, for example, the facility's proposed construction or modification for compliance with technology that can achieve the lowest achievable emission rate. So in short, oftentimes a very stringent inquiry. Now, the facility must also obtain emission offsets from other sources or within their own fence line to make sure that there is no increase in emissions as a result of the project. And like the PSD in the attainment areas, this permitting process is public and it involves public comment and potentially a public hearing. Now, I want to close out this discussion on NSR with a comment about a very common alternative that a lot of sources use, which is to become a synthetic miner. As you can probably infer from this presentation, I realize I've probably gone a little bit long, is that the NSR permitting process is actually very onerous. And so it takes a lot of time and resources for the state agency as well as for the source. And so to achieve similar air quality objectives, many sources that have a PTE above the emission threshold will voluntarily take on restrictions on their operations in the form of a state permit that EPA can then enforce, limiting the source's potential emissions and taking that source outside the definition of a major source. Now, this is called a synthetic miner, and it's an option that I believe is available in almost every state. Now, this synthetic miner process could require the source to install control equipment or take on permit limits. It also could involve operational limits. And there are a number of record keeping and reporting requirements that are also associated with this approach. But this approach can offer benefits in that it is somewhat more streamlined in terms of permitting. And so it is an option that many sources will elect if available, and something to consider as you're evaluating your sources under these programs. So that brings me to the end of my planned remarks. I'm happy to answer questions at the end, but I want to sum up maybe just to say, as you can see, the Clean Air Act imposes a number of very complex and potentially overlapping requirements on emissions from stationary sources. And so determining applicability as well as the relevant thresholds can really be a challenge. And this is particularly true when you're looking at related or integrated state permitting programs. And so I think the key takeaway from my presentation is that you should always ensure that you're undertaking a careful review, both of the federal and state standards and frameworks, in order to help ensure a full understanding of and compliance with the relevant regulatory frameworks. So thank you all very much for your time today, and happy to answer any questions later. Thank you.
Thank you so much, Rachel. I will now hand things over to Gary. And just a reminder to our participants, please do continue to enter in your questions in the question box. Thank you all so much.
Well, thank you, Chandler and ELI. It's delighted to be here, and kudos to everybody on the line today. When I was sitting in your position, and I'm a little bit upset that I did not and wasn't aware of ELI's summer school. This is a fantastic program and a great way to learn. And I have two very difficult acts to follow with Sarah and Rachel. So let's jump right in, I think. So I'm going to cover three primary and major components of the Clean Air Act. Sarah did a fantastic job laying the foundation and touched upon each of these. And then Rachel also set me up well to carry this forward in terms of the mechanisms that Congress included in the Clean Air Act to make the various regulations enforceable, and the authorities Congress granted to the U.S. Environmental Protection Agency and others to ensure that sources are in fact complying with those requirements. So I'll touch upon permitting, enforcement, and also litigation and judicial review of Clean Air Act rules as well. So Rachel did a fantastic job covering the NSR program, so I'm not gonna touch upon that, but there are two major permit programs under the Clean Air Act. You have the NSR program, which Rachel touched upon, and what I'll focus on is the Title V permit program. The Title V permit program, and Sarah had a nice slide identifying each of the titles of the Clean Air Act. Title V is one of them. It is a title that was added in 1990 to the Clean Air Act, and it establishes a federal operating permit program. Prior to 1990, when the Clean Air Act was amended to include, among other things, this permit program, there was a sort of sundry of various permits and things like that that sources and EPA and regulators would turn to really understand the various requirements that a regulated source and an emission source must comply with. Congress changed that in 1990. And it established the Title V program, which is very much intended to be a one-stop shop, right? To have one permit that consolidates all of the various quote unquote applicable requirements in one place. So sources don't have to search through a number of pre-construction permits or state issued air quality permits to really understand the regulations that they must comply with under the Clean Air Act and state laws. Instead, Congress established this Title V program to consolidate all those requirements into one permit document. The Title V program applies to major stationary sources, and Rachel touched upon this when she discussed the NESHAPs, or the National Emission Standards for Hazardous Air Pollutants, which govern the emission of hazardous air pollutants. The major stationary source threshold for those sources subject to those requirements is 10 tons per year PTE of any hazardous air pollutant, or 25 tons per year combined emissions of hazardous air pollutants. Sources, stationary sources can also be major for emissions of criteria pollutants, and Sarah discussed what the 6 criteria pollutants are. Generally, the default major stationary source PTE threshold for the purposes of the Title V permit program is 100 tons per year. So if you are a particular source and you have actual or potential emissions of 100 tons per year or more of any one of those 6 criteria pollutants, you are considered a major stationary source for purposes of the Title V permit program. That default level of 100 tons per year can and does go down depending on whether the particular airshed in which the source is located is in attainment or non-attainment. Rachel touched upon this as well, and I've listed it and described it as Title V by law sources. And the Clean Air Act does require a number of various industrial categories and sources to obtain Title V permits, even though they may not be considered major. I think for purposes of today's discussion, it's fair to say that generally major stationary sources are subject to the Title V permit program requirement, but just know that there are certain predefined sources that are not otherwise considered major that must obtain a Title V permit as well. I noted that a Title V permit is a consolidation of all applicable requirements. So what are those requirements? We've touched upon a number of those today. There are emission limits, there are monitoring requirements. So how do you measure your emissions, determine whether you're meeting a specified emission limit from, for example, a new source performance standard or a NESHAP requirement. There are reporting provisions. So major stationary sources must, for example, on a semi-annual basis, report to the permitting authority as to whether they're meeting the monitoring requirements in their permit. And then annually, Title V sources must certify compliance with all of the various requirements in their Title V permit. And those are, fairly massive undertakings. I mean, when you're dealing with a very complex source like a petroleum refinery, for example, or Rachel touched upon the oil and gas sector, and you're dealing with a natural gas processing plant. The various requirements that are included in a permit like that, you're talking about 100 or more pages of a permit, and a source is required annually to certify compliance with each of those. It's something that I know a lot of my clients take very, very seriously. I know EPA takes it very seriously, and I know the U.S. Department of Justice also looks into those issues as well. Title V permits, in addition to NSR permits, there's a fair amount of administrative process and procedures associated with the issuance of those permits. There's public notice and comment. At least for me now in my current role, a number of my clients turn to us to assist them with working with the permitting authorities, the state and local agencies that are responsible for issuing these permits. And those agencies are often amenable to working with permitted sources to really understand and discuss the requirements that they intend to include, whether it be in the initial Title V permit or the renewal Title V permit. So there's a fair amount of process involved in the issuance of Clean Air Act permits, Title V permits specifically. And Title V permits are issued for a 5-year term. That's a fairly common permit term for environmental regulatory programs. So every 5 years, a source that's otherwise regulated is going to have to apply for renewal. And then the permitting authority is going to have to go about reviewing that renewal application and then ultimately renewing the permit. I mean, as with a number of environmental deadlines and timelines, the Clean Air Act is a good example of this. Sometimes those deadlines are not met, and 5 years becomes 10 and so on. But that's, I think, very much a function of the complexity of the Title V permit program generally, and it can take time to work through that. And facilities change, emission sources change during permit terms and the like. So, it's no small undertaking to deal with sources that are subject to the Title V permit program. I've touched upon this already, but although the Title V permit and the new source review permit program are creatures of the Clean Air Act, they're implemented primarily by states and state environmental protection agencies. In some cases, tribal authorities have the ability to implement directly Clean Air Act permit programs. For certain types of sources and for reasons I won't really get into today, US EPA can issue a Title V permit program to a source. And then I touched upon this. The public doesn't have the ability to issue Title V permits by any means, but they are key players in the Title V and NSR permitting process through the notice and comment procedures that are associated with these permit programs and just general advocacy altogether. The public is certainly a key voice in that process. So I touched upon at an extremely high level one core aspect of the Clean Air Act and implementing the Clean Air Act requirements, and that's permitting. I'm going to focus, I think, a fair amount of my time today on a really important and near and dear to my heart component of the Clean Air Act process, and that's enforcement. Chandler provided a very kind introduction. I appreciate that. In my past life, I worked for the U.S. Environmental Protection Agency out of its regional office in Chicago, and in my roughly 8 years there, focused almost exclusively on enforcement, and a big component of that was enforcement of the Clean Air Act. So let's jump right in here and discuss this. And for enforcement, I break it down into 4 separate buckets. You have administrative enforcement. So those are enforcement actions that are US EPA initiated and really US EPA adjudicated and concluded actions. The Clean Air Act grants the US EPA authority to issue compliance orders. Those are orders requiring a source to comply with a certain Clean Air Act requirement. The Clean Air Act also gives the US EPA authority to impose civil penalties on a source for violating a Clean Air Act requirement. The administrative enforcement mechanisms in the Clean Air Act, I think it's fair to say, and when it comes to US EPA's authority, Congress circumscribed US EPA's authority in some respects. I think by design, Congress recognized, and we've touched upon, and we said the word complex, I don't know how many times today when you're talking about the Clean Air Act, you just can't avoid it. And in the enforcement context, that certainly is brought to bear. And Congress recognized that, when you're talking about enforcing some of the very, very complex, costly Clean Air Act requirements, it gave EPA authority to do things like require sources to comply and then issue civil penalties, but it didn't give it full carte blanche authority to do that. EPA can require a source to comply as expeditiously as practicable, but no longer than 1 year after issuing a compliance order, for example. In the Clean Air Act, compliance can take well over 1 year when you're talking about installing multi-million-dollar pollution control equipment, for example, at sources across the country. That whole process can take many, many years. EPA's civil penalty authority is also relatively circumscribed. EPA has authority to impose civil penalties for violations that occurred no more than 12 months prior to the issuance of a civil penalty order, and is also by statute capped when it comes to the amount of civil penalty it can seek. So what that means is in the Clean Air Act enforcement and civil judicial enforcement context specifically, and Sarah knows this well from her experience at DOJ, is that oftentimes the US Department of Justice is involved in Clean Air Act enforcement. I just think that given the complexity and the nature of enforcement generally under the Clean Air Act, invariably DOJ will be at the table. And DOJ in that context very much serves as the outside law firm for EPA. It represents EPA in federal court, and EPA in that respect is often looked at in terms of the client. States and tribes are also often involved in civil judicial enforcement actions, and they often have a seat at the table. Sometimes they bring a different perspective, right? The state and the tribe, may be intimately familiar with the operations of a particular facility by virtue of the fact that it's close to that facility. It is inspected that facility far more than EPA has. And a number of stakeholders are leaning on it to obtain perhaps relief in addition to that being sought by even US DOJ or EPA. The Clean Air Act, in addition to civil, judicial, and administrative enforcement, authorizes criminal enforcement actions. There, it's the US Department of Justice, or I said it again, Justice, that is leading the charge there, and it's often US attorneys that are bringing those criminal actions. EPA does play a role there. EPA has criminal agents, special agents that it employs to investigate alleged criminal violations. Criminal violations are reserved, and I think are relatively rare in the Clean Air Act context. They're reserved to knowing violations of the Clean Air Act, although In the mobile source context in particular, we've seen, I think, some uptick in criminal enforcement actions for mobile sources. And that last but certainly not least, I'm going to go back here, sorry. We have citizen suits under the Clean Air Act. So the Clean Air Act, as do many federal environmental laws, they authorize the public to commence lawsuits against a regulated source. There's special process and procedures associated with those requirements. So the public group, oftentimes it can include a nonprofit organization like the Sierra Club or Justice or the National Resources Defense Council. They can initiate those types of lawsuits after providing a notice of intent to sue. And that notice is designed to give EPA at least 60 days to take its own action. But if EPA doesn't take action within that 60-day period, the group providing that notice can initiate its own enforcement action and obtain really, in many respects, the same relief that the US Department of Justice and EPA can obtain. So importantly, these enforcement authorities just don't come out of the blue, right? I mean, there's a recognition by Congress in the Clean Air Act and many environmental laws that, in order to enforce the requirements of the Clean Air Act, EPA is going to need investigation authorities. And the Clean Air Act provides those. It provides EPA with the ability to inspect facilities. Oftentimes, those inspections are in person, although, particularly during COVID and the pandemic where we were all working from home, EPA and I know a number of state environmental agencies began engaging in virtual inspections, utilizing technological platforms to do what they otherwise were not able to do safely in person in terms of inspections. The Clean Air Act allows EPA to monitor sources. So Sarah touched upon this in her remarks. The Clean Air Act in particular is seeing, with advancements in pollution monitoring technology, we're seeing a lot of interesting ways that EPA as well as citizens groups are collecting air emissions data. And I know in the last 10 years or so, EPA has purchased a number of advanced pollution monitoring technologies. EPA has a van that contains pollution sampling technology that it's able to drive around in particular neighborhoods or near a facility's fence line and collect emissions data. EPA inspectors utilize infrared cameras to visualize emissions that can't otherwise be seen by the naked eye. The Clean Air Act doesn't necessarily authorize EPA to use those technologies, but it does broadly allow EPA to inspect and to monitor. I mean, EPA technically could also, under the Clean Air Act, measure directly emissions from a stack at a facility. It often doesn't do that and turns to and requires sources themselves to do that type of monitoring, but I think EPA could do that under the Clean Air Act if it chose to. Another key investigation authority EPA has is what's known as information requests. Those are written documents where EPA asks sources a number of various questions about, for example, records that they're required to keep, and asks the source to provide records that it's required to keep to demonstrate compliance with the Clean Air Act requirements. They can require sources to, as I noted, test their emissions. They can require sources to install monitors at fence lines, for example. And those information requests, they can be extremely broad. They can be really in-depth requests, in some respects, seeking decades or more worth of information that a source has been required to obtain and maintain under the Clean Air Act to demonstrate compliance. So they're no small undertaking. That's something I assist clients with, when they receive those, understanding what EPA's authority is, under the Clean Air Act in terms of making requests for information, and then ultimately how to go about responding and providing responsive information to those requests. Last but not least, and I just sort of mentioned this for edification purposes primarily, EPA does have administrative subpoena authority under the Clean Air Act. I think, what that may look like, I think it's fair to say, at least in my experience, that's rarely invoked, but to the extent that EPA feels it's not getting information from an information request to a regulated source, a company, for example, it does have the ability to subpoena maybe a plant manager and require that plant manager to provide certain information. But again, that authority, I have not seen it and haven't been personally involved in EPA utilizing that investigation authority under the Clean Air Act. So what does a federal administrative or civil judicial enforcement action really look like in practice? EPA, DOJ, I think on EPA's behalf could go into court, the next day or the day that it does discover a violation. And in certain circumstances, if the situation is grave enough, perhaps it has and will do that. That's usually not what happens, though. More often than not, there is a fair amount of notice provided if you happen to be a company that is the focus of an EPA enforcement action. The initial notice often comes in, and this is another acronym I didn't list here, but an NOV or an FOV is what they're known. They're notices of violation or findings of violation. In some respects, the Clean Air Act requires EPA to provide these notifications to a source that EPA believes may be in non-compliance. In other respects, EPA just does it out of policy and practice. But an NOV or an FOV, if you were to Google and find one, I think, I would say it looks a lot like, a complaint. It has a caption oftentimes. It lists the factual background that EPA believes is relevant. It often lists the statutory and regulatory basis for the alleged violations, and then it itemizes the alleged violations that EPA believes apply to the particular source. Usually what is followed by an NOV or an FOV is what's known as a Clean Air Act Section 113 conference. And depending on the type of violation, this is actually required under the Clean Air Act. But I think EPA, it's referred to as the Section 113 conference, and whether EPA is required to provide this opportunity or not, it usually does. And so the 113 conference, I think, is the sources or the regulated parties' opportunity to share information that EPA may not have been aware of, or that the source believes EPA should be aware of when it comes to the alleged violations, and then just have a candid dialogue. I think, more often than not, my clients view those conferences as extremely beneficial, right? It's an opportunity to get before EPA. If you don't already have a rapport with EPA, to establish one, to provide information that's beneficial and that EPA should be aware of, and to really, inform EPA of, oftentimes the company's culture of compliance and the fact that it does prioritize environmental compliance. And so I find those meetings to be very beneficial. Usually, those meetings can include and can commence a formal negotiations process, or a negotiations process can occur shortly thereafter. And we've talked about the complexity of the Clean Air Act. Negotiations, whether it be in the administrative or civil judicial context, they can take years. And that's because, there's a lot on the table. These sources are very complex. The regulations are complex. Oftentimes, the economic implications of a position that EPA or DOJ may be taking are huge, right? They can make or break a company, perhaps, and that company is, and oftentimes EPA and DOJ are also looking for ways to ensure that the company and the regulated party can continue to operate, but come into compliance with the Clean Air Act requirements. And Sarah touched upon this also in her remarks. We're seeing a lot of focus, particularly in this administration, on environmental justice. And so negotiations can include other parties at the table, right? What are the community's concerns with respect to the enforcement actions, and how are how are EPA and DOJ meeting those concerns? And in some respects, the community group or the stakeholders within the community may also have a seat at the table in those discussions. If you're successful in negotiations, you'll resolve the issues, right? And that resolution will be memorialized in either an administrative or judicial settlement agreement. In the administrative context, settlement agreements can take any number of forms. Judicially, they're often embodied in a consent decree that is actually lodged and entered by a district court and enforceable by that district court. And those can be often complex documents, right? Hundreds of pages, appendices that include all sorts of programs and requirements. So it's no small undertaking to conclude and ultimately resolve and then memorialize that resolution in a consent decree and even an administrative settlement document. And then, if you find yourself unable to resolve something, litigation, does occur in the enforcement context. I would say that in my experience, the vast majority of enforcement actions are resolved short of litigation. But there are some instances where litigation does occur and DOJ on behalf of EPA is litigating. There's discovery, there's motion practice, there's there are even trials, related to Clean Air Act enforcement actions, but those tend to be rare. So, what are we really looking for? What are EPA and DOJ looking for in an administrative or civil enforcement action? And what does the Clean Air Act authorize them to obtain? And I've listed here, I'll say the first two are really the primary components of an enforcement action. First, civil penalties. And due to inflation and due to sort of federal legislation that's been put in place, the statutory civil penalty maximums are increasing to account for inflation. And where we are, I think today, is we're at about $50,000 per day per violation for a Clean Air Act civil penalty. So as you can imagine, when you're dealing with allegations of multiple years of non-compliance for multiple different Clean Air Act regulatory requirements, the civil penalties can become massive and they can become significant, millions of dollars. And so, oftentimes that's where resolutions come in and companies see the value of resolving things because litigating a civil penalty on a Clean Air Act matter can be a risky undertaking, I think both for the federal government and regulated parties. But, EPA and DOJ, I think, on the civil judicial side, also tend to prioritize injunctive relief. So what is that? What injunctive relief is requiring a source to comply with the Clean Air Act requirements. That is so much simpler than in practice what it is. It's imposing emission limitations. It's requiring a source to monitor emissions. It's requiring a source to report compliance with those emissions. And that can not only include what is required in the new source performance standards, for example, or the NESHAPs, or the Title V permit, but it can go beyond that in a enforcement action. And the consent decrees often include their own set of injunctive relief that can go beyond, really the letter of the regulation. I've listed here that injunctive relief includes mitigation. And this is really a creature of, I think, primarily of EPA policy. But the whole idea is that if you're dealing with a source that has exceeded an emission limit for, let's just pick a criteria pollutant or a precursor to a criteria pollutant, volatile organic compounds, for example. And let's say the emission standard is 100 tons per year of VOCs from a particular emission source at a facility. And EPA believes that source has been emitting, in reality, 200 tons per year for 3 years. Mitigation is very much designed to sort of ratchet down an emission limit to mitigate for or account for past excess emissions. So limiting a source's future ability to emit VOCs in this example to make up for excess past emissions. And that's something that's relatively recent sort of creature and priority of EPA, and we're seeing it, I think, more and more in particularly the civil judicial context, and certainly in EPA's own enforcement actions as well. The last bullet here that I've listed, supplemental environmental projects. I mean, we could talk about this for a very, very long time. Suffice to say, it's become, at least in the Trump administration, what are known as SEPs, another acronym, sort of were a lightning rod for controversy, and there are questions about whether SEPs, which are another creature of EPA policy, are in fact legal or not. I think that the Trump administration took the view that they were not, for a variety of reasons, issued a number of policies. Those policies came out of, a number of them came out of the US Department of Justice. And then there was a rulemaking associated with this too. The policies have since been withdrawn by the Biden administration. So depending on who you listen to here, SEPs are back on the table, although there is this regulatory requirement out there that is arguably serving as a roadblock to using SEPs, which are civil penalty mitigation vehicles. So the SEP is above and beyond, right, anything that would be required by law. And the whole idea is that there is a nexus to the violation at issue, and that it allows the regulated party to minimize its civil penalty exposure by performing this supplemental environmental project to offset the amount it would otherwise pay to the federal treasury for a civil penalty. So last but certainly not least, I focused on two primary mechanisms, permitting and enforcement, that Congress authorized EPA and DOJ and others in the Clean Air Act to ensure that the NSPS, the NESHAPs, the NACs, as Sarah touched upon, are all implemented. Those are mechanisms to implement those core concepts and constructs of the Clean Air Act. There's another aspect, and I included this slide, and Chandler and I discussed it because this is something for those of you that are in law school or considering going to law school, something that keeps environmental attorneys busy, whether they be in the Department of Justice, EPA, or even in private practice in some respects as well. There's the Clean Air Act includes a massive, massive amount of rulemakings and rules. And those rules, and Rachel did a fantastic job touching on two of those primary rulemaking programs under the Clean Air Act. There are thousands and thousands of pages of regulations, and the Clean Air Act includes and mandates oftentimes that EPA by certain deadlines revisit things like the NESHAPs and the new source performance standards, and take advantage of modern day pollution control technologies, for example, account for the costs of compliance and those types of things, and consider whether it needs to revise and modernize those requirements. EPA does that, and when it does, particularly for major rulemakings, I think invariably there are legal challenges. Those legal challenges to major US EPA rulemakings, the venue for those is in the Federal Circuit Courts of Appeals. I've listed in number one here, the court that hears most of these challenges, right? I mean, I think we're talking about federal standards that apply everywhere to all sources across the United States, those nationally applicable regulations. Challenges to those major rulemakings are heard before and in the DC Circuit Court of Appeals. It is a major judicial body that hears and decides challenges to US EPA rulemakings. Now, where a particular EPA rulemaking, Sarah touched upon state implementation plan rulemakings, those are more localized in nature. Challenges to those rulemakings are heard in the more local federal appellate court that governs that particular jurisdiction. So that is certainly an option too, but I think most major EPA rulemakings are challenged because they're dealing with nationally applicable regulations in the DC Circuit Court of Appeals. There's a fair amount of litigation also under the Clean Air Act against EPA for failure to perform what I've listed here as a non-discretionary act. So as I noted, the statute includes deadlines. EPA needs to revisit the NESHAPs, the new source performance standards, on statutory required timelines. Sometimes it doesn't meet those deadlines, and frankly, some of those deadlines are very, very aggressive. And that opens up opportunities, and the Clean Air Act provides the opportunity for whether it be industrial sources or more often than not, environmental nonprofit groups to petition EPA to take action. Oftentimes that includes, 180 days or so notice, of an environmental group or an industrial source saying, EPA, you need to revisit this particular new source performance standard. You're required to do so under the Clean Air Act. If EPA doesn't do so within that 180-day period, oftentimes, the source can then sue EPA in federal court. And those actions for failure to perform a non-discretionary act are heard in the US district courts. I've listed here, and Chandler and I mentioned this, and Sarah touched upon it too. The Clean Air Act is, we talked about greenhouse gas emissions. It's becoming, if you ask people that were involved, particularly in the 1990 Clean Air Act amendments, whether they envision the fact that the Clean Air Act, wouldn't be amended in 30 years, and there's really no prospect right now, I think, with the way things are going in Congress, for it to be amended anytime soon, although we'll see, that the statute would remain as is for this long. And I think there's some push-pull here, and you're seeing some, depending on the change in administration and the administration in power, really testing the limits of the Clean Air Act in many respects, and seeing how it can be used to address, modern day issues associated with, for example, climate change and tackling climate change and regulating greenhouse gas emissions, which those types of problems I don't think were contemplated by Congress, certainly not in the 1970s, and I don't think in the 1990s either, when the Clean Air Act was last amended. So I've listed here 3, relatively recent significant US Supreme Court decisions, all governing and all dealing with, in some way, shape, or form, the use of the Clean Air Act to regulate greenhouse gas emissions. And I'm not going to really belabor them. I know I've probably reached the end of my time here, but these are very, very significant decisions. Again, all dealing with greenhouse gas emissions in some respects. Massachusetts versus EPA was an extremely, extremely important case that I think, what happened there was the Supreme Court, in a narrow decision, it was a 5-4 decision, held that air pollutant under the Clean Air Act is defined broadly to include greenhouse gas emissions. And that, I think that decision, it's fair to say, was just a fundamental change in the way that the Clean Air Act was used, particularly on the greenhouse gas side. And it opened up a lot of doors for what we're seeing today in terms of what EPA is doing and how EPA is using the Clean Air Act when it comes to regulating greenhouse gas emissions. And these next 2 decisions, American Electric Power versus Connecticut, and then the Utility Air Regulatory Group versus EPA, I would say, where Massachusetts versus EPA kind of put a line in the sand and gave EPA opened up a lot of doors for EPA. AEP, the American Electric Power decision, then UARG, or the Utility Air Regulatory Group decision, in some respects sort of curtailed, EPA's authority here. I mean, AEP was really dealing with, I think, the fact that, federal common law can no longer be required, or a source of authority to limit a source's greenhouse gas emissions. And, it essentially provided for, preemption-like approach to regulating greenhouse gas emissions under the Clean Air Act, and turned to EPA for relief there. The court there said that greenhouse gas emissions can be regulated under new source performance standards, and therefore, federal courts in particular better be and are prohibited from using nuisance theories for granting relief for greenhouse gas emissions related violations. UARG, I think, certainly fits the mold of EPA. Really swung for the fences there, and Rachel mentioned an NSR program. UARG involved a rulemaking that EPA promulgated where greenhouse gas emissions would be directly regulated under the NSR program. And the Supreme Court there, in some respects, in a lot of respects, vacated that rule and said that, greenhouse gas emissions alone cannot be a reason that a source needs to obtain an NSR permit or even a Title V permit. But the court there did allow for what are known as anyway sources, so sources that are otherwise subject to the NSR program and the Title V permit program, for those permitting authorities to regulate greenhouse gas emissions from those sources. So it left a couple of doors open, or at least for EPA and the permitting authorities to regulate greenhouse gases under those Clean Air Act regulatory programs, but it certainly closed the doors on EPA when it comes to just broad regulation of greenhouse gas emissions under the NSR and Title V permit programs. So like Rachel and Sarah, I just want to thank you all. I know, Chandler mentioned we have a number of questions, so I'm happy to answer questions in today's Q&A or offline, and my contact information is listed here. By all means, reach out to me if you have questions that you weren't able to cover, weren't comfortable covering today. I'd be happy to speak with you about what a Clean Air Act practitioner in practice looks like in the private sector or at EPA.
Excellent. Well, thank you all so much for your excellent presentations. We will now use the remaining minutes to jump right into our Q&A session. So as a reminder to our participants, please enter your questions using GoTo's question box. We do have a number of questions already. We probably will not have time for all of these questions, but I'm going to throw the first couple of questions out to Sarah, and Rachel and Gary, both please feel most welcome to follow in and chime in as much as you feel comfortable. So this first question is methane considered a criteria pollutant?
Thank you so much, Chandler, and thank you to Gary and Rachel. As I said, we're all in a learning posture, and it's great to learn from our practitioners. So thank you for the first question. And no, methane is not a criteria pollutant. This tees up, though, an important point, which is just because a pollutant or a substance is not a criteria pollutant, it's still able to be regulated under the Act. And methane, you bring up a really important example, as some of the audience may know, methane's an extremely powerful greenhouse gas. It's very potent. And by that, I mean it's something like 80 times stronger than carbon dioxide at trapping heat, even though it lasts less long in the atmosphere. So it's a very important pollutant to regulate. And if you're interested in kind of following the back and forth over methane regulations, there was actually regulations promulgated under the Obama administration, and that looked something like monitoring, detecting and repairing leaks, for example, at natural gas wells. And then the Trump administration attempted to roll back those regulations. So we'll see what happens as we progress forward. But as I said, a very important pollutant to regulate. It's also a pollutant that is often co-emitted with other pollutants. And by that, I just mean that we see where we see methane coming out, we also see something like a carcinogen like benzene, like volatile organic compounds and the like. So again, an important pollutant to regulate.
Great. Rachel or Gary, did you have anything to add?
I'll just like to add, I mean, methane is, as Sarah noted, directly regulated from oil and natural gas sources, and then existing landfills are also subject to methane requirements. And there are efforts afoot now by certain groups to have methane regulated directly as a volatile organic compound under the Clean Air Act.
Excellent. This next question is also for you, Sarah. The question is, why is there an unclassifiable air quality? Is it because of technical problems to capture the air quality?
Another great question. So what I believe the commenter is asking about is those designations under Section 107, right? When we're looking to establish the NACs and then implement them through the SIP program. So under Section 107, if EPA cannot designate an area on the basis of available information, so your hypothesis is correct there. If on the basis of available information they can't detect whether or not it meets the standards, they then say it's unclassifiable. In those situations, though, and Gary and Rachel, you can weigh in on this, I believe that EPA also has to determine that that there's no evidence that it looks like the area is in non-attainment. I think they have to make sure that it's not looking like the area is in non-attainment, and they also have to make sure that whatever they're saying is an unclassifiable area is unlikely to contribute to a violation in another area. So that's my understanding of it. And as I said, Gary and Rachel, you can weigh in. But I'd like to raise a related point, which is a very popular place where we're seeing scientists and academics explore, and that's the lack of monitoring across the country when we're talking about ambient air monitoring. I'm happy, whoever asked the question, I'll give my contact information again, but I would be happy to share the flurry of studies that's come out recently about the lack of consistent monitoring. I was talking on a mobile source panel, I guess a couple of months ago now, with the pandemic, working from home, my sense of time is not quite what it used to be. I think it was a couple months ago, and we were talking about this exact issue, and I think there was a statistic about only 20% of the country having monitoring, counties in the country having monitoring for fine particulate matter. So there's really, again, that's why I raised the issue of low cost technology that's going to push some of the Clean Air Act implementation forward right now, because we really need to see broader monitoring and removal of what some scholars like Ann Carlson, for example, out of UCLA calls hotspots, pollution hotspots, and she has a great article called the Clean Air Act's Blind Spot, if anyone's interested in learning more about this exact problem.
Excellent, thank you so much. Gary or Rachel, did you have anything to add there?
Yeah, I'd just like to add a little bit. It's not directly responsive to the question, but I think it does nicely tie together some of the themes that we've hit on today, which is that, as Sarah said, as the EPA avails itself of these new technologies, or states avail themselves of new technologies to ensure more robust monitoring, I think, as Gary spoke about, we may see some trends in enforcement and permitting that focus on some of the priorities of this current administration, and in particular, the environmental justice focus that we've seen President Biden and his administration hit so heavily in the first several months. And so I think we'll be looking to see how those new technologies are utilized, particularly in fence line communities and vulnerable communities and underprivileged communities, as part of enforcement or as part of permitting tools that the agency brings to bear.
And I'll add one thing too, not directly responsive to the question. And I know, Sarah, I'm interested in reading that article you mentioned, but in Pittsburgh, where I live, interestingly enough, the Liberty Air Monitor is something that is reported on in the local newspaper, and the results from it, you could go, I think I could go online today and find from the local permitting authority here what the results are at that air monitor. So at least where I live, I don't know whether there's a perception of whether there needs to be more monitors, but one of them in the area is sort of known, and I would say well known probably to those that are picking up the local newspaper and understanding what the air quality like is in the region on any given day.
All right. Thank you both. Thank you all so much. This next question I think is really geared towards Rachel, but Gary or Sarah, if you want to jump in on it, please feel free to do so. This question says, there are several existing major sources of pollution that are not new or modified. What are the barriers to requiring all facilities, not just new or modified ones, from taking steps to limit their air pollution?
Yeah, that's a great question, and I think it actually highlights yet another theme we've talked about, which is that the Clean Air Act has not been updated in quite some time, and so industry operates under the framework that is in place, and obviously the Clean Air Act applies as it currently is drafted to existing or modified sources. Now, to keep up with technology, of course, major sources are going to have to undertake modifications, and so that's one way in which major sources can be regulated that are already in existence and are not new construction. But I do think it is one area where the states in particular could take a more active role in continuing to evaluate sources from emissions and from sources that do not fall under the Clean Air Act. I don't know if Sarah or Gary, anything to add. I'd welcome your thoughts as well.
I think this is one area where we're actually seeing, EPA be more aggressive, and we can talk about a recent action that deals with. Rachel mentioned the new source performance standards, and there's a specific provision in the Clean Air Act that requires EPA to regulate existing sources that would otherwise be regulated as new sources under the new source performance standard, and that is, certainly something that has led to a lot of recent litigation and rulemakings by EPA. So in that respect, the statute doesn't pose a barrier to something like that. Actually, the statute requires and arguably mandates EPA to take action in that instance.
And I'll just add sort of a very quick point that a couple of the comments have raised, and I think we all mentioned this, that the lack of updating of the Clean Air Act, and Rachel just talked about, sources have to comply with what's on the books, and that's true. But I don't want people to leave without knowing that there is some change in how we approach the Clean Air Act and how it's implemented. And a lot of that is actually driven by something, and I hesitate to mention this, but it's driven by something called the Chevron doctrine. And I promise, for those of you who are in the audience who are practitioners going, please don't teach us Chevron, I won't. But because of that, it's the Chevron doctrine, and I'm happy to answer questions about it offline. But this gives expert agencies discretion in their area of expertise in interpretation and promulgation of regulations. And so in that way, we're still moving forward. The difference is we don't have new statutory language that we're interpreting in the Act. So that's the difference. I just want to highlight that to show this when we talk about the Obama administration, for example, promulgating certain regulations that the Trump administration may have attempted to roll back, and we'll see how the Biden administration interprets certain things or what types of regulations they try to promulgate. That's part of what we're talking about there.
This next question, Rachel, I'll start with you, but I think really this could be one for everybody. I think it's a really great question. It asks, what is the general consensus on emission offsets? There's been criticism of it being greenwashing, but is it still a common policy in states or nationally?
That is a good question. I will actually invite Gary and Sarah to jump in. I think that might be a little bit of a tough question.
Well, I mean, I'm not going to walk right into this, but I think, well, maybe I am. I think there's a difference between emission offsets. I think the question is asking, although I want to be careful here, about what we're hearing about a lot now in terms of net zero goals and things like that, and offsetting emissions for purposes other than what is required under the Clean Air Act. I think that's how I'm interpreting that question. And in that sense, I think there may be some programs. California, I think, has some of those, but I'm not heavily involved in those types of aspects of clients' involvement, but I mean, I think that's a fair question. I know a lot of people are talking about whether, for example, whether there's enough, credits available for preserving and conserving forest lands, for example, to offset emissions. And I think a lot of folks are calling it greenwashing, or are, raising, questions that I think are going to continue to be asked going forward as, regulated parties and perhaps even regulatory agencies move in the direction of requiring those offsets.
Great. Next two questions, Gary, I'll start with you, but again, anyone, please feel free to jump in. This question asks, if a portion of the SIP is not being enforced, what would be the best strategy to get it enforced? Petition the EPA, a citizen suit, or something else?
I'm going to give the classic lawyerly response that it depends. Right? I mean, I think it depends on what's not being enforced and who thinks that it needs to be enforced. That the person or company or whomever it may be that feels as if the SIP is not being enforced may not have the means to enforce it, right? And so in that instance, I know EPA, they have hotlines and other things that complaints can be can be lodged and made to it. I know from my experience that some of the enforcement cases I worked on at EPA began by complaints that were called into a hotline, and that was the reason that a particular source was investigated. Now, to the extent that the community or the person believes that, or the person is associated with a sophisticated operation like a major environmental group, they certainly know how to enforce alleged SIP violations and know how to pull the levers of the Clean Air Act to ensure that those requirements are being enforced.
Yeah, I'll just jump in and say I believe, and again, happy to chat this out with anyone, but I believe my friends over at Earth Justice have some good samples of litigation where citizens are trying to enforce or trying to get EPA to enforce part of a SIP over the last 4 years. And I will echo Gary's comment regarding citizen complaints and tips coming in. I had a case very early on into my 8 years at Justice that arose from a citizen complaint for a construction site that wasn't meeting Clean Water Act provisions. So it's a very, very powerful tool. And when I speak with foreign delegations sometimes on enforcement issues, one of the crown jewels of our federal environmental system is the ability for our citizens to step into the shoes as private attorneys general and take on an enforcement role. It's very important.
Perfect. We have one more question. This one, I think, is we can start with Gary. I think it's a very interesting constitutional question here. It asks, do EPA inspections ever implicate Fourth Amendment search and seizure issues?
Most definitely. They do, but I mean, I think they can in some respects, but what you're going to see more often than not, particularly with my clients, is a willingness to cooperate with EPA, right? I mean, there may be instances where, there's a search and seizure issue implicated, but that's when, the implication of taking that position, I think, is something that shouldn't be taken lightly. I mean, the agency is not going to view that kindly. They're going to suspect that you have something to hide. And, that may be why you're taking that position in the first instance. But I certainly think they can. There are probably instances in history where they have. I would say, though, that more often than not, the Fourth Amendment is not implicated in an EPA inspection. Sources are cooperative. Sources are, bringing EPA in and allowing them to ask the questions, providing records. But it certainly, I think, it can arise. It just doesn't very often, at least in my experience.
So I'll add to that, and I certainly want to leave space for Rachel to comment on this as well, just from an enforcement perspective. And then also, I teach an advanced seminar on environmental practice, and we talk about this issue. So, yes, these issues can be implicated in information gathering authorities and inspection authorities, but two things I would note. So first, oftentimes a condition of your permit is that you agree to these inspections. And second, some courts have held that given that this is such a pervasively regulated industry, depending on what you're doing, you just don't have that reasonable expectation of privacy, the same way you might find a private citizen, for example, would have that expectation of privacy. That's my understanding of what occurs. But I just want to also echo what Gary said, which is the vast majority of times when people are undergoing, when facilities are inspected, usually it's a process where they have a lawyer present or a technical person present to really walk the inspectors through. That's usually just the best practice. There is the ability to secure what's called an administrative warrant for a search as well. That is very, very, very rarely used.
Yeah, I will echo what Gary and Sarah said. I think in large part, it behooves the entity under investigation to try and be cooperative with such requests, and particularly because there is kind of this hammer waiting at the end, which is that the agency could go to court and get access to this information oftentimes if it needed to. And so in my experience in representing clients in enforcement actions, in investigations, it's been kind of an opportunity for the regulated entity to share information that might help its case or tell its story and frame it in a way that helps the agency understand why perhaps the violation at issue is either not a violation or not as severe as the circumstances might otherwise seem it to be. And so while it's certainly true that these issues may be implicated, I think oftentimes the information request, investigative interrogatory or Section 208 request can be an opportunity for the regulated entity as well.
Excellent. Well, unfortunately, we do not have time for any more questions. We did receive a number of questions, so folks, I really would encourage you to follow up and ask your questions offline. I think you did really ask some really great questions. I just want to say thank you so much to our participants for joining us today and for your many thoughtful questions. We hope you'll continue to think about the foundations of environmental law, especially the Clean Air Act. We are so grateful for you for participating in ELI's annual summer school series, and we hope to welcome you back next Tuesday, where we will explore hazardous waste and sites. I want to extend another thank you to our amazing panel, Sarah, Rachel, and Gary. Thank you all so much for lending your expertise to summer school. Thank you all again. Please take care and stay safe. Thanks, everybody.